Another step in the process to free Kelsey Fitzsimmons from jail was taken today by her legal team. After all, there is no legal basis for Kelsey Fitzsimmons to be held in jail pending her eventual trial. So just to catch you up briefly on what happened to Kelsey Fitzsimmons up until this point, let's just briefly recap. Kelsey Fitzsimmons initially was arraigned from her hospital bed. The reason why she was arraigned from the hospital bed is because she was shot. She was shot in the chest, and she had, as you can imagine, many injuries that are associated with being shot. So she was arraigned from her hospital bed, but she was in the hospital for like 53 days. And then she was charged, she was put in jail, and then she was released on bond. But she had a laundry list of restrictions and requirements that she had to comply with in order to get out on bond. One of which was house arrest. Another one was that she had to blow into this scram device. Now, a scram device for somebody who has broken ribs and other internal injuries is very difficult. As you can imagine, you have to blow for an extended amount of time in order for it to register, and it was causing her excruciating pain. So Timothy Bradel, being very proactive and exactly how all the judges ask the attorneys and want the attorneys to act, he filed immediately a motion to modify her bond restrictions. After all the judges always tell you, don't wait for your client to be in violation of bond. Let us know right away if your client has any sort of difficulty in complying with the restrictions. So that's exactly what Timothy Bradel did. He did that. He filed this motion, and we all heard the hearing. And in that hearing, the judge stormed off the bench and revoked her bond, threw her back in prison. So Timothy Bradel filed a motion for reconsideration with the same judge, and unsurprisingly, the judge denied the motion for reconsideration. Then he appealed it to the single justice, and the single justice agreed with the lower court judge, and now he then made an appeal to the full panel. So first, the full panel has to accept the appeal. So what happened up until this point is that we were waiting for the full panel to accept it. The full panel did accept it, and now they have to submit more briefing in front of the full panel. And that's what just happened today. Timothy Bradel filed this final appeal with the full panel of the SJC, and then the other side now is going to have an opportunity to respond, and then maybe there's going to be an oral argument. We don't know quite yet if there's going to be an oral argument or if the SJC full panel is going to decide on the briefs alone. That is still yet to be determined. But this is the next step in order to get Kelsey out of jail. So we are going to be going through some of the appeal. We're not going to be going to rehash everything. If you're familiar with this case, great. If you're not, we did a number of videos on it, but we're just going to be highlighting some of the arguments that they make and some of the things that they kind of beefed up, which I'm very happy about, in this final appeal brief to the full bench. So here we go. Let's pull it up and we'll go through some of the portions of this appeal, and you'll really get, in case you're just joining us right now for this case, you'll get a good flavor of what's been going on with Kelsey Fitzsimmons and why there is really no legal basis for her to be in jail at this point. All right, so let's start from here. The parties appeared before the court, Judge McCarthy Naiman, the next day. An appellant requested alternatives for scram testing. Now take a look at footnote 2. Ms. Fitzsimmons respectfully submits that it is important for this court to listen to the recording of the trial court bail hearing, which recording was submitted to the SJC on a thumb drive with the 221 memorandum. Now, if you've heard the hearing, then you'll understand why it's important for the full panel to hear how that judge acted and spoke to and conducted herself in that hearing. The single justice apparently only reviewed the transcripts later provided by the Commonwealth and was not able to appreciate the actual treatment of the defense and the probation department, which is made clear by listening to the hearing culminating in the judge departing the bench while defense counsel was mid-argument. Okay, so hopefully the full panel will listen to that hearing, because if they do, again, there's a lot of legal basis even without listening to that. But once you listen to that hearing, you know exactly, and you kind of feel the emotions that that judge made the determination, and not really based on the law and also all the errors that you made. Okay. Continuing. What should have happened could have taken 5 minutes, where the defense reported the difficulties and had an alternative method of alcohol testing put in place. Instead, a completely improper nightmare scenario played out. Rather than utilizing a readily available common alternative method of alcohol testing, which would be urine, the court surrendered the appellant back to jail without a request to do so from either the Commonwealth or probation, in violation of 58B. We all know about 58B, which is the statute which talks about when someone violates their bond, then you can go and revoke their bond. But here, there was no violation. The court shut down the probation officer, cut off counsel, walked off the bench while the undersigned was arguing for his client. In writing, she accused the defense of manipulating the situation and repeatedly misstated the record. As you all remember in that breakup letter, the opinion, she was accusing them of manipulating her and manipulating the process. So let's move on. Going back to the statement of facts, a lot of you know this, but let's just go on to some interesting parts of the statement of facts. That day, her fiance and baby's father told her to meet him at a local park, and instead stood her and the baby up and got an ex parte restraining order with an affidavit full of shocking lies. And again, this footnote is also very important, where it says, in no free society should a person be able to go to a court, fill out a form, and send the police to a new mother's home and take a baby away from her without an opportunity to be heard. Okay, so that's what just happened. Unfortunately, the department's decision to avoid body cameras leaves the case as a he said, she said. Remember what happened there was that, what did she actually do? Did she point the gun at Officer Noonan, or did she point it at her own head or her own body somewhere? Well, because they decided not to have body cameras installed, well, we don't know. So now it's a he said, she said exercise, and seriously hinders the strength of the Commonwealth's case, a highly relevant factor in the bail determination. With only Ms. Fitzsimmons and Officer Noonan on the second floor of the home, so in case you're wondering, well, was there any witnesses in this case? The answer is no. It was only Kelsey Fitzsimmons and Officer Noonan. So it's literally a he said, she said. So with only Ms. Fitzsimmons and Officer Noonan on the second floor of the home, Officer Noonan stated that Ms. Fitzsimmons, kneeling on the floor of her bedroom, lunged behind a door and reappeared pointing a firearm at him. Kelsey Fitzsimmons adamantly denies ever pointing a firearm at another person. Now take a look at this footnote, because that's, I think, very interesting. Look at this footnote. It is notable that there is no door to or in Ms. Fitzsimmons' bedroom. So I'm not sure how could she have lunged behind a door and grabbed a gun and pointed it at Officer Noonan. So there's some real problems with his story right there. Okay, continuing on. Since the court's wholesale denials of the defense filings, Ms. Fitzsimmons has been held at the Western Massachusetts Women's Correctional Facility in Chicopee, Massachusetts, where she has been in solitary confinement due to her status as a police officer and former corrections officer. Now, she probably that is probably the safest place for her, but if you think about it, it's not such a great place for you when you just had a baby and you just got off of postpartum depression to now be in solitary confinement. Since being incarcerated, Ms. Fitzsimmons has been threatened by a male inmate when he found out something about that bee. Okay. Far from posing a danger, she has passed the many hurdles as becoming an officer, sworn in oath, and has been entrusted by the community to protect them from danger. Remember, there's this issue of, well, maybe she's a danger to the community. Maybe she's a danger to Officer Noonan, which, again, is one of the biggest jokes about this ruling in the first place. So, no, she's far from posing a danger, and she passed all the hurdles to becoming an officer and was entrusted with the community to protect them from danger. So, no, she's not exactly a danger to the community. The nature of the incident is also inconsistent with the requirement that there be clear and convincing evidence of some ongoing risk of future danger. On the Commonwealth allegations, Ms. Fitzsimmons assaulted the officer with a gun in the course of attempting self-harm due to a complete collapse of everything important to her at the moment. At best, on the Commonwealth's allegations, the officer was placed in apprehension in the course of events that had nothing to do with him personally. There is no animus or motive to harm him going forward. In fact, the record points in the complete opposite direction, meaning maybe Kelsey Fitzsimmons harbors this very evil will towards Officer Noonan. Is that the case or not? Well, look at this. Ms. Fitzsimmons publicly stated that officer was not just a colleague, he was my friend, meaning referring to Officer Noonan. That officer and I experienced a very difficult and sad call for service together last summer. That call for service that day was a true tragedy and caused this officer and I to build a friendship due to experiencing it together. So she was on a call with Officer Noonan on this very sad call where there was a real tragedy, and that actually brought them together. That brought them closer together as friends. To this day, his support during that hard time is something I am still grateful for, regardless of this recent incident that occurred. So it's not like she's harboring any of this animus towards him. There is no likelihood that Ms. Fitzsimmons, stripped of her firearms, a bit over 5 feet tall and 110 pounds, who can barely take a deep breath, would put the SWAT-trained armed officer or anyone else in danger going forward. So just a great way to summarize what this danger that the judge was so concerned about, that Officer Kelsey is going to present to Officer Noonan, because after all, she doesn't have a firearm. She's 5 feet tall and 110 pounds, and she can barely take a deep breath. She is gravely injured and presently scheduled for her 5th operation at MGH. She should benefit from reasonable accommodations under the Americans with Disabilities Act rather than be housed in a prison cell. Alcohol was an irrational focus of the trial court. Just in general, the whole idea of her having to test for alcohol was also irrational. There is no likelihood that alcohol consumption is a real factor here. The incident had nothing whatsoever to do with alcohol. Drinking the weekend before at her bachelorette party is hardly a bellwether of ongoing alcohol abuse by a new mother and full-time sworn police officer. Her serious ongoing medical struggles all but rule out alcohol abuse and manifestly do not require an unyielding approach to alcohol testing. She should not be required to satisfy phantom concerns, and if the court for some reason deems such testing necessary, she can easily drive 10 minutes down the road for urine testing rather than being tortured with a constantly recurring breath test. And there is the terrifying Kelsey Fitzsimmons. I mean, you look at this picture and you're like, you're terrified. You're running for the hills when you see this picture of Kelsey Fitzsimmons. I mean, look at that. And she is literally about to jump out of that car and just attack anybody within the vicinity. All right. So going into some of the arguments here, but I want to highlight one of the arguments that I thought is a very strong argument. But let's get through it one at a time. In supporting its decision, the court resorted to attacking the attorneys on alleged procedural deficiencies and manipulation in its written rulings on the events of September 11th, and in denying the reconsideration and ignoring the medical evidence it claimed was initially missing. Right? Remember all that procedure? Oh, well, you didn't attach medical records, and you're just trying to manipulate the system by filing all these motions and having all these hearings in front of me. What's wrong with you as a lawyer? What are you doing filing these motions? Like the court's supposed to be some place where you hear motions on legal matters. What's wrong with you, Timothy? Although largely academic in light of the overarching impropriety of jailing Ms. Fitzsimmons, regardless of which law applies, the single justice also wrongly applied the basis for the surrender, choosing 58A4, and that was the basis. Remember, I told you before, the judge could not have used 58B. She had to use 58A because 58B is very clear that there has to be a violation in order to revoke someone's bond. So therefore, she had to figure out how to apply somehow 58A4. And again, like we went through, 58A4 also does not apply to this situation. And we're going to see why even more as we go on. Section 58A4, setting out the conditions where a dangerousness hearing can be reopened, was not followed by the court. So even if you want to say, well, 58A4 says that a dangerous hearing could be reopened, that's what the court relied on, 58A4. Now, I would first of all submit, as I've mentioned in previous videos, that actually, if you actually read 58A4, it talks about someone who has been arrested, has been detained. But even that aside, even if, let's say, the person, you want to read into the statute that the person does not have to be arrested and ignore the plain language of the statute. Okay. And therefore the court could reopen the hearing. There's another very big problem with 58A4 if you don't follow it the way that it was intended to be followed. That provision requires due process. You've heard me talk about due process when it has to do with Kelsey Fitzsimmons, the fact that there was none here. Notice an opportunity to be heard as spelled out in the section. 58A4 says that there has to be a hearing. There has to be a hearing. You can reopen the hearing, but everybody then has to be on notice that you're reopening the hearing with the possibility of the bail being revoked. That's what due process requires. There has to be notice of what is going on. You can't, as a judge, say, we're going to come back to court to talk about this motion to, modify your bond restrictions, whether you can go into a scram device or not. And then all of a sudden at the hearing say, you know what, we're just going to revoke your bond. Whoa, where was the notice that may be an issue in front of the court right now? So even if the court wants to reopen under 58A4, if they want to reopen this hearing, and they have to give notice, that's built into the statute. That underpins that is an underpinning of the statute. So it was not followed by the court, obviously, in this case. Notice opportunity to be heard as spelled out in the section. Ms. Fitzsimmons was there under 58A2 seeking a hearing to amend her release conditions. She was not in violation of any provision and was neither a Commonwealth nor probation department target of a revocation or a reopening of the dangerousness hearing. The judge was the only person aware of a reopening of such a hearing where reincarceration, not reincarnation. That's for a different topic on a different video, but for where reincarceration was planned. So the only person in that room who even knew that may be on the table was the judge. And I think she kind of decided that last minute. As such, none of the procedural safeguards were honored as set forth in 58A4, i.e., notice that such a shocking result was even being considered a right, with that knowledge, to call witnesses, have informed counsel the right to testify, cross-examine, and present witnesses, and to benefit from a correct interpretation of the relaxed rules of evidence. So that, I think, this paragraph, I think, is maybe the strongest argument, I believe is the strongest argument, and why there is no legal basis for it to be in jail right now, because no one had any sort of notice or opportunity to be heard on this issue. Yes, there was notice and opportunity to be heard on the issue of modifying her restrictions, which would mean, is she going to do scram testing? Does she have to do scram testing? Can we do urine testing? And then the judge would say yes or no on that. That was what everybody had notice and opportunity to be heard on. Not, oh, by the way, this may be a hearing where we're going to completely destroy her liberty and take it away and lock her up. Nobody was on notice on that, and nobody had the opportunity to be heard on that. Okay, continuing down. Then they're talking about there's also some the hearsay issue, where she said, well, that's hearsay. Well, you're allowed to introduce hearsay in these type of hearings. So they go through a lot of what the court says there, and how the court was cutting off the probation officer and saying, you don't get to decide what's a violation of bond. I get to decide. So we're not going to go through all that. We all heard it before. And now it gets into the last part, which is the court violated the Americans with the Disabilities Act. And this is where, when you have someone with disabilities, because I don't know, maybe they were shot. So then, then you have to accommodate them, assuming that they have these disabilities. Then you have to accommodate them under the statute. So they go through this, also laying out all of her disabilities and the requirement that the judge accommodate the person with those disabilities. So that is the final part of this appeal brief. And there we get to the conclusion. The court should have granted release on personal recognizance with standard stay-away orders. That's really what they're asking for. There should be a personal recognizance type of bond, and instead of a laundry list of restrictions. The court clearly dispensed with the safeguards that bail be revoked only after finding a violation of terms, and that there be no combination of conditions that would allow the defendant's release. The court did not further the bail statute's purpose of establishing the right of the accused in most circumstances to be admitted to bail. If this court believes there should be conditions set, there are ample alternatives to Section 58A incarceration for Ms. Fitzsimmons, all of which were assiduously avoided by the trial court. So, for the foregoing reasons, Ms. Fitzsimmons respectfully requests that the Supreme Judicial Court, number one, address the bail determination de novo. Remember, that was one of the issues where they're arguing that the single justice applied the wrong standard of review here. The standard of review here, when it has to do with a bail revocation, is de novo review. De novo means you look at it fresh. You don't give any sort of deference to the lower court's decision. Abuse of discretion is when you determine whether the judge abused her discretion. And that is the incorrect standard here. So it has to be de novo. You look at everything fresh. That's number one. Number two, what do they want? Grant Ms. Fitzsimmons liberty with personal recognizance and a stay-away order from the alleged victim under Section 57 or Section 87 of the bail statute, and vacate the balance of the trial court order, including the provisions handicapping the probate and family court from handling the custody and visitation decisions in the case, and or grant other such non-incarcerative relief in the alternative if the court deems 58A conditions necessary, and send this case back to the Essex Superior Court before a different judge for the reasons set forth above. I mean, obviously, they would want to get a different judge on this case. So this is really very briefly what the appeal is about. Again, we broke down a lot of the appeal already, some of these arguments, so we don't have to reiterate all the arguments that are made, but I think I like the part that they beefed up the part about the due process violation, because I think that really is, when you have a constitutional argument here, which is obviously included in 58A4, which is what the judge was basing her decision on, there still has to be due process considerations. Of course, you have to follow the Constitution, and it wasn't done in this case. So yes, there's some other arguments here. There's the American with Disabilities Act, and there's it's really 58B type of revocation. And if you just listen to the hearing, that's really all they're going to need to hear anyway. So this is a great step in the direction of getting Kelsey Fitzsimmons out of jail. She should be out of jail, and we'll see what the response is with all of these arguments. We'll see. I mean, maybe the Commonwealth won't. Maybe they'll decide that, you know what, they're right. Maybe we won't even file a response, but they're probably going to file a response. So that is where we are right now. Again, hopefully this matter will be expedited as quickly as possible so that Kelsey can get out, who knows, before even December hits. So that would be nice. So that's where we are. We're going to be continuing to follow everything that goes on with Kelsey Fitzsimmons and this injustice. And hopefully she will get out of jail, be reunited with her baby, and then she can go forward and concentrate on the custody issue, which unfortunately she also has to face, and this potential trial where she has on this criminal charges, which again is going to be, I think, a very difficult case for the Commonwealth to prove when you have a he says, she says, and nobody else. What type of experts are they going to be able to show that she actually was pointing the gun at him as opposed to pointing it at herself? I don't know. That's a pretty uphill battle right there. So we'll see. We'll see what happens with this case, but we're going to continue to follow it. If you haven't yet, please subscribe and like, and we will see you next time.